come to the next section, which is section 17. In the previous section, you saw that there was a moratorium, there was a public announcement, and there was a appointment of the IRP. Next, we go to management of affairs of the corporate person by the interim resolution professional. From the date of appointment of the IRP, the management of the corporate debtor will vest with the IRP. The powers of the board of directors or the partners of the corporate debtor, as the case may be, stand suspended. So it's sort of suspended, but the board exists, but it's suspended, and shall be exercised by the IRP. Officers and managers of the debtor shall report to the IRP. Officers shall provide access to documents, information, records, everything that the IRP wants. Financial institutions maintaining accounts shall act on the results of the instructions of the IRP in relation to such accounts and furnish all information relating to the corporate debtor which is available with them. The IRP vested with the management shall act and execute in the name and on behalf of, shall act and execute in the name and on behalf of the corporate debtor all deeds, receipts and other documents. Take such actions subject to such restrictions as may be specified by the board. This board that we are talking about is not the board of directors, it's IBBI. Have the authority to access the electronic records of the corporate debtor from any information utility. Have access to the books of accounts, records and other relevant documents of the corporate debtor which could be available with government authorities, statutory auditors, accountants and such other persons as may be specified. So this actually says the RP shall take over the company, the board shall stand suspended, officers shall report to him, banks and financial institutions shall operate under his mandate, company officers shall provide information, other authorities also shall provide information to the RP, government, auditor, chartered accountant. He shall execute documents on behalf of the corporate debtor. He shall take such actions as may be necessary also. And he has authority to access the electronic records. Then we come, here again there are some interesting case laws which examined whether the corporate debtor after appointing an RP has the right to even go back to a legal process or file a case in an NCLT or bring up an appeal. It was held that the corporate debtor has that right. So I'll discuss that case again later when I discuss the part with the case laws. Duties of the IRP. Now we gave the IRP certain rights. Obviously these rights come with some duties. The IRP shall perform the following duties. First, he shall collect all information in relation to the corporate debtor. He has to determine the financial position of the corporate debtor because he is here to resolve. His objective is to get a resolution plan approved. So what will he do for that? First, he will collect financial information and he has to present it in the form of reports, which is operations and payment, financial and operational payments for the previous 2 years, business operations for the previous 2 years. Then, list of assets and liabilities as at the initiation date, that means application date, and such other matters as may be prescribed. These specified are all there in the regulation. Then, what does he do? So, as soon as he comes, he assesses the financial position, prepares the statement of assets and liabilities, prepares a finance and operation payment report, prepares an operation report. Then what will happen? He would have given the public announcement. He will receive claims, collate. He will constitute the committee of creditors. He will monitor the assets of the corporate debtor and manage its operations until an RP is appointed by the COC. So for that, here these are functions, the duties of an IRP. He will manage the affairs till an RP is appointed, file information collected with the information utility, take control and custody of the corporate debtor, where the corporate of assets over which the corporate debtor has ownership rights as recorded in the balance sheet or information utility or depository or any other registry. So he has to take custody and control of the assets of the corporate debtor. He can't say, no, I will check only in the information utility. No. He has to check. He can't say, I am taking only from the balance sheet. So it's balance sheet, information utility, any other registry. Could be your ROC, charge. Could be your SurfaceC, central register. Or depository of securities. So if my securities are held in a demat form. So if he has to take possession of all assets over which the debtor has ownership rights. Okay. So what are the categories of assets he will take and he should not take is again specified here. All assets on which the corporate debtor has ownership rights, whether or not he's got the possession, including shares of a subsidiary. Okay. Second, assets where he has ownership rights which may be located even in a foreign country, whether they are in the possession or not in the possession of the debtor, tangible or intangible, movable or immovable, assets subject to determination by court or authority, and securities including shares held in a subsidiary, insurance policies, financial instruments. What cannot be taken by this person? Assets of a subsidiary cannot be taken. Shares in a subsidiary can be taken. 2. Where he is only holding possession but does not have ownership. Let's assume he is a subcontractor for, let's say, a large automobile manufacturer. They've given him some tools to manufacture, but the tools are not owned by the corporate debtor. I can't take those. 2. Assets under bailment. And 3. Such other assets. Okay. So first is assets owned by a third party, held under trust or under contractual arrangements including bailment. 2. Assets of any Indian or foreign subsidiary of the corporate debtor. And 3. Such other assets as may be notified by the central government in consultation with the central government financial sector regulator. So you have to remember basically 4. Owned by third party in possession, trust, bailment, shares in subsidiary, Indian or foreign. Then we go to section 19. Personnel, here you can have questions on what are the included assets here and what assets he cannot take over. Okay. Personnel to extend cooperation to IRP. The personnel of the corporate debtor, promoter, any other person associated with the management shall render all possible assistance and cooperation. Where any personnel of the corporate debtor, promoter or any other person does not assist, he can apply to the adjudicating authority for directions. So that's what a lot of IRPs will say, okay, I'm going to apply under section 19 if the CD is not cooperating. The adjudicating authority on receiving an application under subsection 2 shall by an order direct such personnel or other person to comply with the instructions. So AA will give an order directing him to comply with the information and cooperate with him for collecting the information. Then you come to section 20, which is the management of operation of the corporate debtor as a going concern. See, you read even in the definitions, resolution plan is what is coming up to keep the debtor as a going concern. If resolution plan doesn't happen, then it goes into liquidation, in which case the going concern assumption is lost. So management of operations, so IRP shall endeavor to protect and preserve the value of the property, to enable the corporate debtor to carry on its operations as a going concern. For this purpose, he can appoint such professionals as may be necessary, which is accountant, legal or other professionals, enter into contracts on behalf of the corporate debtor, or to amend or modify those contracts. Okay. Third, to raise interim finance without the prior consent of the creditors, who's provided you cannot raise interim finance if you don't have the consent of the creditors who had the security over such assets that you are now planning to charge. Okay. So if it's an encumbered property, you need consent of the creditors whose debt is secured, provided such consent, this is important, is not necessary where the value of the property is not less than twice the amount of debt. So you can conservatively say twice the amount of debt after the interim finance.
Okay.
This slightly ambiguous there. But suppose I have a property which is worth 200 crores today. And we've taken only a 20 crore. I can go up to 100 without the consent of the COC. But then that's what this section seems to imply. To issue instructions to personnel that are necessary for keeping it as a going concern, to take all such actions as may be necessary. Now you may ask me one question, should I memorize all this? No. But what will happen in the exams is they'll give you a statement and they might give you one of these as the option. Management of debtors is a going concern. It gives the professional the authority to take loans endlessly. No. To remove statutory auditors and all people relevant to the management. No. Raise any amount of interim finance. No. The fourth option will be to raise interim finance provided there is a consent of the committee of creditors. Similarly, you can have another question. The interim resolution professional can raise interim finance any amount, charge any property, any amount but without charging any property, without the consent. So if you're broadly getting the drift of what I mean, one of these will be an option in the answers, which is why you need to repeatedly read all this. With this we'll stop here because after this it goes into a slightly longer section. So we'll talk about the remaining starting from section 21 in the next segment. Stay on for more.